Retired military John Doe went on TV as a military expert to comment on a press article that mentioned the alleged use of a flamethrower to punish some soldiers. He explained how a flamethrower works and said, if it were true that the young men were punished with a flamethrower, the situation would be very, very serious, because, among other reasons, the use of this type of weapon requires premeditation, moot court exercise. For his statements, he was prosecuted for the crime of slander against the National Armed Forces. The crime, set out in the Organic Military Justice Code, says, whoever slanders, offends, or disparages the National Armed Forces or any of its units shall be subject to 3 to 8 years in prison. The national final judicial ruling sentenced John Doe to 5 years and 6 months of prison.
Extract from the statute that was relied upon by the state, the Organic Military Justice Code. And you've got a little excerpt from it. Whoever slanders, offends, or disparages the National Armed Forces or any, and a sentence of 5 years and 6 months was issued. Some of you may think that's harsh, some of you may think that is the right punishment for suggesting these things. So we have our constituents. Defence. Give his opinion. Freedom here. Very experienced looking panel.
Wise.
20 prosecutors and 20 defence lawyers on a Saturday. So, how long should we give them?
15? Yeah, 15 minutes.
15 minutes. One person? One person. Yes, Mahesh. One person. So you need to select an advocate as part of the process.
You have to select somebody who is really going to defend the case. I mean, maybe you're the regional court or you're the Supreme Court, and you are deciding if you support, of course you support, you want to break this decision, and you are going to decide yes or no, which argument you think are the most solid. And then afterwards we will discuss together.
Just I will add. These must be applied, and on that basis argument must be placed. How it is prosecuting and
what is that? Organic military justice. Organic military justice. What is that?
Mr. Mehdi. Mr. Mehdi,
I was talking to the judges.
No, they don't hear who are there.
And I will hand over to the honourable judges.
Yes, may it please your honor. Here in this case, looking to the facts and circumstances of the case, it has been informed that it is an appeal preferred by the person who has been convicted by the lower court. And the facts are that the retired military personnel has participated as an expert comment in a press media house, and he was expressing his opinion on the article which has been published.
What is the article?
The article that is there. They said that he said that the some military the press article that mentioned that alleged use of flamethrower to punish some soldiers. If it is so done, the situation is very serious because among other reasons, the use of this type of weapons requires premeditation.
That is what?
That is what. And he says that if looking to the facts and circumstances of the case, we have come to the conclusion that the flamethrower has been used to punish some soldiers, and he being expert, he says that if it is so being done, it requires a premeditation. If I am not wrong. Because facts and circumstances of the case.
You are arguing the case.
So the fact is that, this is a TV show he's part, or he's commenting it in front of the TV. He is only he said that if this was true, whatever the article says that a flamethrower was used to punish some soldiers. So he is saying if this is true, then it's a very serious, very, very serious. Look at the terminology, very, very serious. And he is also saying that this type of use of weapon requires premeditation, which means that somebody has to think through this and then plan it and then act. So that is what he is saying. So for his statement, he was prosecuted under slander against the National Armed Forces. So and he was also sentenced to 5 years and 6 months of prison. That's the facts of the case.
Then you have to answer.
So now, yeah.
And we will answer it. See, basically, it is an opinion expressed by the military personnel.
It is not what he is written.
He has written.
Yes, guaranteed in the article.
It is not what he has written.
No, he is a retired.
He is retired. He is a retired military officer. He is commenting on an article, first of all. So it is his freedom of expression. He is expressing it freely. And looking at the context of what he is talking, where he is talking, it is based on an article. He being the retired military officer, it is his duty to come in support of the organization of the military unit he has worked for. So, he is supporting, he is saying that this is not true. So that is being...
There is an issue, if I may say. I'm going to be a judge now. I'm going to be a judge.
Basically, though he is a retired military servant.
No, sorry. I'm part of the judge.
Then I will be part of
Okay, you're part of it. So first of all, order. The defense doesn't seem to be agree with itself. I suggest the defense to make yourself agree with one voice instead of dissenting in now, because you're doing the job of the prosecutor. You're not defending your client, and I might give you a fine.
On submission, there is another entry, illegal entry. What is it now?
Order, you're part of the defense team. Okay, so put some order in the defense team, please.
I will explain you, I want some order in the rule court. My lord, the issue is very, very serious one. The person who has attended the next, who expressed his opinion in the panel on article, he has been seriously charged and he has been punished. It is against the fundamental right of the Indian Constitution as well as Article 19 of the ICCPR, because we are human rights. We are human beings who are actually enjoying the human rights. So suppose I am the retired military officer now, I am the civilian now, I am having an extreme enjoyment of the freedom of speech and expression. If I am the part of the institution, automatically I will be bound by the service conditions, and I am bound by the implications and other restrictions imposed by administration. But as a retired officer, I am a civilian now. So as a civilian, I have much more fundamentals to enjoy. So when I am in the panel, I have expressed my view regarding the article. In the article, it has been expressed that they have largely mentioned that the flamethrower has been done against the soldiers to punish them. So automatically, I expressed what is the process of flamethrowing. To commit a flamethrowing or to do some flamethrowing act. What are the processes to be followed by the military officers? Then they have to use a weapon, they have to fail it, then they have to plan where to use it, again who will use it. Then I explained the process. I have not explained anything against my military system, military unit at all. I explained the process. Explaining the process, is it an offending act?
And also being a retired military person.
So I explained the process. My explanation and process will not, because my context was, I was asked what is the process of using the flamethrower.
Thank you.
Mr. Mahesh, thanks. One defendant at defending. One. Thank you.
He has rightly said, it is only expression of his opinion, and it has also been pointed out that he not being continued as a soldier. But you can take up a situation. He has worked as a soldier, but after retired he is also concerned about the life and safety of the person against whom the flamethrower has been used. And he says, he condemns if at all it has been used, it is a serious issue. And slander meaning the action or a crime of making a false spoken statement damaging a person's reputation. He has been punished for slander and for slander against the national armed forces. The definition of slander is slander meaning the action or a crime of making a false spoken statement damaging to a person's reputation. Here he himself has not made any statement. He is only expressing the opinion on the basis of the report which has been published. And even he goes to the extent of saying that even if it has been done, it is not good. And therefore, there was no any occasion for him to putting into a punishment, because he had no any intention to degrade or to see that the reputation of the armed forces is diminished. And the antecedent, if it has been seen, he was also a military personnel and disciplined person, and he knows what are the procedures which are required to be followed. And in spite of that, he says if the flamethrower is used, that requires a premeditation. And he said that no, that whatever it has been, that premeditation in the sense that they planned to use it and done it. And he says that doing such an act is not correct. And he said, whether he has incited anything to do, whether his statement has given effect to anything, it has not been incited. It is he is commenting on the incident which has happened regarding what is already published. And the truth is the best defense, wherein even for an offender in a good faith, making a statement under good faith without there being any intention to incite or without there being any intention to disrepute anybody, therefore there is no question of slander. And therefore, the slander against national forces, because it offends the disproportionate, damages the national armed forces of its unit, so doesn't affect the national security in any manner. He is speaking only what incident was according to as per the report. This incident was happened. The report was published, and he was expressing his opinion. And he has not derogated any armed forces. And he
Your Honor, as well as my colleagues, the Defence Council, as they have proven that the punishment which has been given, as the Defence Council proven that the provided statement is against the freedom of expression and all. We want to know whether the Defense Council has provided the facts before the court, first of all. Yes, and as you said, the freedom of expression in the Article 1 of A, the Article 1 of B also says that though everybody has a freedom of expression, it should not be a matter of national security issues. As being a retired person from a military, how a person can state something against his own organization wherein he has known the rules and regulations? It is the constitutional powers. The retired officers do not have the constitutional powers to say something against the national security issues, which is in way he had done the play of demoralizing the soldiers, demoralizing the system. That is what the act says, slander against the national armed forces. Who is working and even after his retirement, he or she should not state anything against the national armed forces. Wherein the fourth paragraph says that the crime set out in the Organic Military Justice Code says they are clearly informed that whoever slanders, offends or disparages the national armed forces or any of its units shall be subject to 3 to 8 years in prison. Here I would like to highlight the point that this said person, the military expert, has violated the Military Justice Code. Wherein we are considering his position or the status of a speaker. As our international standards says, the position and the status of a speaker is not being of a common man, but as a retired military expert. So that matters the first. And the second thing is, slander is when we are opposing someone. That is crime. When we cannot say something against our national forces, he has done a slander. That is what the word says there. And the word premeditated, what does it mean? Premeditated in the sense, how come the soldiers are having a premeditated state of mind wherein they are taking direct offices from their higher authorities. They cannot do anything on their own. So here, we do not have the power of expressing ourselves. Hence, what we have thought is, during our service years, we would be coming across the internal information of the military, and every country, every system will be having their own set rules and regulations, which we are not supposed to speak even after our retirement in a public, because the rules which seems very outrageous or ferocious or very furious in terms of the common public. But in terms of military, when it comes to the national security matters and all, we do not take such common and that humanitarian touch things to our military rules. We have to, at certain times, we have to be very furious and all. So, what his statement, though he has simply given an expression and opinion, if certain things have been done, that he says the very, very serious. However, what is the impact of his statement on the people who are working on line, on the borders, as the soldiers? How it would impact them? It is clearly demoralizing his own system, wherein he has worked, he has served until the days of his retirement. So, the punishment which was given to the military expert is reasonable, and that's how we justify. That's why he has been punished with the 5 years and 6 months of prison.
Here the accused has been convicted only up to 5 years. Here that the reasonable punishment has been given, so that deserves the punishment, and he deserves that punishment, and that appeal deserves to be dismissed and same remains.
Can you say the rules? What is the rules that they are banning the expressing the
opinion?
The retired military officer. What is the specific rule that is?
The Military Justice Code, which says
retired military officer.
Yes.
Is there any rule for the commenting later officer or not?
Before it whether it should be expressed by when it applies to the public or not so. go through that the entire that provision, there is no such discrimination. There is no any that immunity for the retired military officers.
Any specific rule 3 or rule 4, can you specify it?
There is no such any that the information given.
You can say the any number. You can say
And particularly, even after retirement, we enjoy certain facilities from the institution where we have worked. So is it not a betrayal to say something against the organization? It is that military, when we are getting a retirement benefits and all, it is, no, it
Court decided.
the punishment given to that said person is very less. In fact, we have to demand more, and we are very sorry to see that our defense council is supporting the traitors of the country.
Yes, violated the right.
Under the guise of expressing his opinion, his his right of freedom of expression. He has violated the code. That code particularly says here that standard against the National Armed Forces and Organic Military Justice Code. He has violated it.
Interference of the people doesn't arise. It is as per the law.
reply. 2 seconds. 1 minute. 1 minute reply. 1 minute. 1 minute.
Your Honor, with respect to the current prosecutor, respected prosecutor, I want to differ because I have a great respect to them. But however, after hearing that the arguments, it appears that it is more than confined to the facts. It is around beating around the bush, and it has been said that the statement which has been made disparages the national armed forces or against the national interest. And rightly it has been said that under which code the retired military officer cannot express his opinion, and even if the opinions are there that are subject to the constitutional rights. If any law,
20 seconds.
If any law is there, any code is there, if it violates the provision of the constitution or a fundamental right of a person, then the constitution of that country and fundamental right prevails upon. Therefore, instead of arguing what was his intention, whether it was a bona fide, whether it was made in good faith, whether it was made in the good humor, without considering all those facts, only and even he has said that he explained how frameworks works, and even he has gone to the extent of said that if it were true, he has not come to the conclusion that it has been done and he has condemned it. And he has gone to the extent of saying that if it were to be true, it is not true.
Okay.
Therefore,
Thank you. The judge has ಯಾರು ಎದ್ರ ಬಗ್ಗೆ ಯಾಕೆ ಏನ್ ಹೇಳಿದ್ರು ಪರಿಣಾಮ ಹೇಳಿಲ್ಲ, ನೀವು ಹೇಳಿಲ್ಲ. ಪಾಯಿಂಟ್ ಏನು ಗೊತ್ತಲ್ಲ ಒಳಗಡೆ ಅಲ್ಲ ಲಾ ಏನಂತ ಅದು ಕಾನೂನುಗಡೆ ಒಳಪಟ್ಟಿದೆ ಒಂದೇ ಪಾಯಿಂಟ್, ಅದು ಅವಶ್ಯಕತೆ ಇದೆ. ಆಮೇಲೆ ಅದು ಪ್ರಪೋರ್ಷನ್ ಎಷ್ಟಾಗಿದೆ ಇದು ಬೇಕಾಗಿದೆ. ನನ್ನ ಕೊಡೋದೇನಪ್ಪ, ಯಾರು ಹೇಳಿದ್ರು, ಅವಾಗ ಹೇಳಿದ್ರು, ಯಾಕಾಗಿ ಹೇಳಿದ್ರು, ಅದ್ರ ಪರಿಣಾಮ ಏನು ಅದನ್ನ ನೀವು ಹೆಂಗ್ ಹೇಳ್ಬೇಕಾಗಿತ್ತು ಅಂದ್ರೆ ಅವ್ರು ಮಾಡ್ತಾರೆ. ಡಿಸಿಷನ್ ಕೊಡ್ತಾರೆ ಈಗ, ಡಿಸಿಷನ್ ಕೊಡ್ತಾರೆ ಈಗ, ಡಿಸಿಷನ್ ಕೊಡ್ತಾರೆ. ಒಂದು ವೇಳೆ ನಾನು ಡಿಫೆನ್ಸ್ ಆಗಿ ನಾನು ಪ್ರಾಸಿಕ್ಯೂಟರ್ ಆಗಿದ್ದೀನಿ ಅನ್ಕೊಂಡು ಪ್ರಾಸಿಕ್ಯೂಟರ್ ಆಗಿದ್ದೀನಿ ಹೇಳ್ತೀನಿ ಫಸ್ಟಿಗೆ. ಅದೇ ಮೆಜಾರಿಟಿ ಫ್ರಾಡ್ ಈಗ ಈಗ ನಾವು ಯಾರು ಗೌರ್ಮೆಂಟ್ ಬಲ್ಲ ಅಫಿಷಿಯಲ್ ಸೀಕ್ರೆಟ್ಸ್ ಆಕ್ಟ್ ಎರಡು ತಡ್ಕೊಂಡ್ರಪ್ಪ. ನಾನು ಹೇಳ್ತೀನಿ ನೀದರ್ ಐ ಆಮ್ ದ ಡಿಫೆನ್ಸ್ ನಾಟ್ ದ ಪ್ರಾಸಿಕ್ಯೂಟರ್. ಈಗ ಅವ್ರು ಮಾಡಿ
So the judges have heard both the sides, and if there is a dissenting judgment, myself and my colleague brother Shashikant are of same view, and my sister is of different view. So the majority wins. So the majority view is. So the allegations made against Mr. John Doe is that he has committed slander and thereby violated the Organic Military Justice Code. So the definition, the learned counsel for the defense argued that he gave the definition of slander. Slander means the action or crime of making a false spoken statement damaging to a person's reputation. So he said that if there is any damage caused to the national armed forces, so there is no damage caused to the national armed forces or to any national security. National security is not at stake. So the learned prosecutor argued at length and vehemently argued that the learned public prosecutor vehemently argued that the retired military person has no authority to express his opinion against national military force. He is demoralizing his own system, and the punishment is reasonable. He has violated the code. So, and he has also prayed to uphold the judgment. So the opinion of the court is that in this case the retired military personnel has participated in a TV show as a military expert. So he is expressing his opinion on an article. It is for the National Armed Forces article which has come out in press. It is for the National Armed Forces to see whether the article is true or not. They have to clarify it, whether the article published is true or not, whether such a thing has happened or not. And freedom of speech is protected as a constitutional right, and people generally have the right to express their opinions and criticism, even if they are former military personnel. However, there are limitations to free speech, and making false statements or engaging in slander against national armed forces or of institution can lead to legal consequences. That is what has happened. But the court is of the view that the prosecution has failed to convince whether the retired army person has any rule in preventing him from expressing his opinion regarding national army forces. He has only commented on article, not defamed. He is also it does not affect any. So the court is of the view that the statement made by the retired army official Mr. John Doe does not affect any national security, as it is argued that by the defense counsel that Mr. John Doe has good track record. He is a family man, and that's all. Yeah, so whatever the statement made by Mr. John Doe does not come under the definition of slander.
He is not defaming the armed forces.
Defaming the armed forces. That is also an opinion of my brother.
Appeal is allowed.
And the appeal is allowed.
The judges regarding the freedom of expression even after return from the military service or for that matter any service. After the retirement, we do not adhere the rules and regulations there in the service while we are in serving that position. But I am depending on one aspect, whether the person after retirement we have to do as and or we have a full freedom of expression or not. That has to be, at least we have to maintain or obeying our rules and regulations where we have served or in what service we are serving. The Government of India has banned by regulation regarding the even for a freedom of expression and speech even after the retirement. So we have to, as a military officers, we have to seek for permission from the government even for commenting or even for publishing any matter or any article or so. Even for expressing himself, he have to have the permission from the government. That notification has been passed by the Government of India in the year 2021, May. So the military officer has not obtained any sanction from the government, or for that matter, appellant has not produced any document, and also the prosecution has also, of course, they have commented about the freedom of expression and other things, and that should be within the parameters of the the code. So my opinion, government has specifically notified the same thing. The appellant have got the no right to comment even after the retirement of the survey. So on that point, as we are the citizen of our country, we should maintain or to obey all the rules and regulations that has been passed by the Government of India. So with that point, I decide with my other judges. Yes.
What is appeal?
Yeah, I am deciding on this. I am only deciding on these aspects.
Yes, you are with us. I totally